Welcome to the deep dive. Today, we're digging into a case that, well, it really became this incredible example of how things like wealth, fame, and just the sheer passage of time can twist everything in the search for justice.
Yeah, we're talking about the Martha Moxley murder. It's this four-decade legal saga, really, that ended with the only person ever convicted, Michael Skakel, having that conviction completely thrown out
Yeah,
permanently.
exactly. And our mission today is to unpack that whole journey. We'll look at the evidence, which was, almost entirely circumstantial. We'll look at that Kennedy connection. How much did that shield the family early on?
And crucially, the legal missteps, the failures that ultimately meant the case, just couldn't hold up under scrutiny years later. It's a fascinating look at the limits of the justice system.
So let's start with the setting because it's just such a stark contrast. This happened in Bellhaven, Greenwich, Connecticut. And if you don't know it, think old money, super exclusive, very, very quiet, picture perfect almost.
Until October 30th, 1975, Mischief Night, the night before Halloween. And that quiet perfection was just shattered by this incredibly brutal, almost frenzied crime.
The victim was Martha Moxley. She was only 15 years old.
And by all accounts, just a really vibrant kid.
Yeah.
People described her as bright, athletic, very outgoing. They even called her the California girl because she stood out a bit in that more reserved New England community.
Full of life. And she lived right across the street, literally from the Skakel family. And that family name would become inseparable from her death.
Now, the Skakels weren't just, your average wealthy family. They were seriously wealthy. Heirs to the Great Lakes Carbon Corporation fortune. Huge money.
But maybe even more significant was their connection to the Kennedys. Rushton Skakel, the father, his sister, was Ethel Skakel Kennedy, Robert F. Kennedy's widow.
Right. So you're not just talking about financial power. You're talking about this massive political and social weight, real influence.
And that context is so important because the Skakel household itself was under a lot of strain by 1975.
Yeah. The mother, Anne, had died from brain cancer back in '73. So Rushton was a single dad raising 7 kids. And the picture painted by various sources is one of, well, not a lot of supervision.
Right. Lots of money seemingly, but maybe not enough parental guidance.
Exactly. And reports of, alcohol use among the kids, including the teenagers involved here, 17-year-old Tommy and 15-year-old Michael. It sounds like it was kind of a chaotic environment behind those big Bellhaven hedges.
So you have this setup, and then the timeline of the case itself. It's just staggering. It's cold for, 2 decades?
Yeah, but 25 years, really.
Yeah.
Then Michael Skakel gets convicted in 2002, serves over 11 years in prison.
Then the conviction gets overturned. Then it gets reinstated.
And then overturned again in 2018. And finally, in 2020, the state just decides, look, we're not going to retry him. Case closed, effectively unsolved.
Okay, it's a lot. Let's unpack this piece by piece. Let's start at the beginning. The crime scene itself and those critical early mistakes in the investigation. #tag2. The crime scene and the initial investigation failures.
Right. So Martha Moxley's last hours were spent at the Skakel house. It was Mischief Night. She was there with other friends, just hanging out.
Pretty normal teenage stuff for the night before Halloween.
Exactly. The last time anyone definitely saw her alive was around 9:30 p.m. She was seen outside, near the Skakel's pool, with Michael's older brother, Tommy Skakel.
And what were they doing?
Accounts say they were flirting, kissing. One description mentions them falling together behind the fence, so some kind of physical interaction was happening.
But then the next morning, Halloween, Martha hasn't come home.
Right, and her mother starts looking for her. Eventually, her body is found, and the location is chilling under a big pine tree in her own family's backyard.
How close was that to her house?
Incredibly close.
Yeah.
Maybe 200 yards or so. Not far at all. And the scene itself, it was brutal. She'd been bludgeoned violently and also stabbed. It suggested a real frenzy, a rage.
When the weapon, this became almost iconic in the case, didn't it?
It really did. It was a Tony Penna 6-iron golf club, and it was shattered. The attacker hit her so hard the shaft broke.
And part of it.
Yeah, chillingly, a piece of that broken shaft was actually driven into her neck. It speaks to the level of violence involved.
Now, the golf club itself, where did it come from?
That's the crucial link. Investigators quickly traced that specific Tony Penna 6-iron back to a set of clubs owned by the Skakel family. The set was missing the 6-iron.
And they found the broken pieces near the body.
Pieces were found at the scene, and the club head itself was found later. The point is, the weapon was undeniably linked to the Skakel household. It came from their property.
So that's a direct physical link between the murder weapon and the Skakel residence. Seems pretty significant.
It is significant. But here's where the problems start, especially looking back from today's perspective. Forensic science in 1975. Well, it wasn't what it is now.
Right. No advanced DNA testing like we have today.
Exactly. So despite the violence, investigators recovered no usable fingerprints from the club fragments or the scene. No usable DNA.
And what about sexual assault? Her clothes were disturbed, right?
Her pants and underwear were pulled down, yes. But the autopsy found no physical evidence of sexual assault. So the motive wasn't clearly sexual violence in that sense.
So the physical evidence links the weapon to the house, but not necessarily to one specific person in that house.
Precisely. That's the key limitation. The club came from the Skakels' property, but forensics couldn't say whose hands were on it that night.
Which means the investigation immediately pivots to who was there, who saw what, and crucially, alibis.
Absolutely. And the focus naturally fell on the Skakel brothers, who were around Martha that night. Tommy Skakel, who was 17.
The one seen kissing her last?
Right. He was the last person confirmed to be with her. His story was they were fooling around, and then she left to go home around 9:30 p.m. Pretty simple.
Okay. And what about Michael Skakel? He was 15, same age as Martha.
Michael's initial alibi was different. He claimed he left the Skakel property around 9:30 p.m. Same time Tommy said Martha left.
Where did he say he went?
He said he walked over to his cousin Jimmy Terrian's house, which was nearby, to watch a Monty Python show on TV. He claimed he stayed there until about 11:30 p.m., then came home and went straight to bed.
Okay, so according to their initial stories, both brothers place Martha leaving around 9:30, and Michael says he wasn't even home for the next 2 hours.
That was the initial account, yes.
But then things get more complicated. Martha kept a diary, didn't she?
She did, and investigators found it. And it contained some entries that, while not direct evidence of the crime, certainly painted a picture of the social dynamics.
What did it say about Michael?
There was an entry from about a month before the murder, September, where Martha wrote about Michael. She said he was so totally out of it that he was being a real ass, and then added, "I really have to stop going over there."
Wow. So that suggests some kind of tension or problematic behavior from Michael towards her, at least in her perception, just weeks before she was killed.
Exactly. It doesn't prove anything about the murder itself, of course.
Yeah.
But it establishes this potentially volatile dynamic. It suggests things weren't always friendly. And the prosecution would later use this to hint at a possible motive, maybe rejection or anger.
And on top of these teenage dynamics, you have this whole other layer for the family's status and the claims of privilege. Did the Kennedy connection actually affect the investigation right from the start?
Well, there are definitely claims and some specific examples that suggest it did. The idea that the Skakel family got treated differently, got courtesies that others wouldn't have because of who they were connected to.
Like what, specific?
The handling of the golf club is probably the most cited example. Police found the broken club shaft near Martha's body pretty quickly on Halloween morning. They knew it was likely the weapon.
Okay.
And they also found the matching club head on the Skakel property near their driveway just hours after the body was discovered. So they've located the key pieces of the murder weapon linked to the Skakel property.
You'd think they'd collect that immediately, right? Bag it as crucial evidence.
You would think. But reports indicate they didn't actually retrieve the club head from the Skakel property until the next day, November 1st.
Why the delay?
The explanation often given, or at least implied, is that they waited until the patriarch, Rushton Skakel, who was away on a hunting trip, returned home.
Wait, they waited for the father of the house where the murder weapon was found to come home before collecting it? That sounds irregular.
Highly irregular, especially when you compare it to how evidence might be collected elsewhere. Some later reports mention that around the same time, police collected bags of potential evidence from a neighbor's house without the owner even being present. The contrast is stark.
It really suggests a level of deference, doesn't it? Like they were walking on eggshells around the Skakels.
That's certainly the implication many drew. Why leave what you suspect is the murder weapon unsecured on the property overnight? It suggests the family's status created an immediate shield, a barrier to standard police procedure.
And did Rushton Skakel continue that pattern when he got back?
It seems so. Early on, he reportedly forbade police access to records related to Tommy Skakel, specifically school records and any mental health records.
So blocking potential avenues of investigation right away.
Effectively, yes. It created this immediate wall of non-cooperation, backed by the family's wealth and connections. It's a clear signal.
So you've got a brutal crime, a weapon linked to the house next door, questionable alibis, hints of tension, and then this immediate sense that the investigation is being hampered, or at least handled differently, because of who the neighbors are.
Exactly. And that combination The lack of definitive forensics plus this atmosphere of privilege meant the investigation, which started with this horrific discovery, just kind of stalled. It lost momentum quickly.
And that set the stage for decades of silence. #3, the long cold case and the turning point.
Yeah, for almost 25 years, the Martha Moxley case just sat there, cold. The initial leads didn't pan out. The investigation hit that wall we talked about.
Who were the main suspects during that long period?
For a lot of that time, the focus remained, to some extent, on Tommy Skakel, simply because he was the last person known to be with her.
Makes sense.
And also Kenneth Littleton, who was the Skakel family's live-in tutor at the time. He had moved in only hours before the murder, had a history of mental health issues, and failed a lie detector test. So he was definitely under suspicion for a long while.
But nothing solid enough to lead to charges against either of them.
Nope. The case just languished. Lack of evidence, maybe lack of will, perhaps the continued influence of the family, probably a combination of all those things. It really seemed like it might just fade away. Another unsolved tragedy.
Until the 1990s, what happened then? What brought it back?
It wasn't really internal police work that revived it initially. It was external pressure, largely from the media and the literary world. Things started heating up after the William Kennedy Smith rape trial in 1991.
How did that connect? He's another Kennedy cousin, right?
Right. William Kennedy Smith is Ethel Kennedy's nephew, making him a cousin to the Skakel children through their Aunt Ethel. That trial put the whole Kennedy-adjacent world back under this intense media spotlight.
And that drew attention back to this old, unsolved case in Greenwich.
It certainly did, especially for one writer, Dominic Dunn. He had covered the Smith trial extensively for Vanity Fair, and he apparently became fascinated by the Moxley case, seeing parallels in the themes of wealth, privilege, and potential scandal.
So what did he do?
In 1993, he published a novel called A Season in Purgatory. Now, it wasn't explicitly about the Moxley case, it was fiction. A roman à clef, as they call it.
Meaning a novel with a key, where real people and events are disguised.
Exactly. Martha Moxley became a character named Winifred Utley. The Skakel family became the powerful, privileged Bradley family. But anyone following the news knew exactly what and who he was writing about.
And the book was popular?
Hugely popular, became a bestseller, later a TV miniseries. And by fictionalizing it, Dunn managed to explore the themes of untouchable wealth, and maybe even a cover-up, in a way that captured the public imagination. It put massive attention back on the real case. People started asking questions again.
So Dunn's novel sort of cracked the door open again.
It definitely did. And then, a few years later, came another book, this one nonfiction and even more direct.
Who wrote that one?
Mark Fuhrman, the former LAPD detective, famous, or maybe infamous, from the O.J. Simpson trial.
Right, the detective who found the bloody glove.
That's him. In 1998, Fuhrman published Murder in Greenwich. And unlike Dunn's novel, Fuhrman wasn't subtle. He flat-out named Michael Skakel as the killer.
Wow. Based on what?
Fuhrman claimed he had reinvestigated the case, found new information, and highlighted what he saw as massive mistakes in deference in the original 1975 police work. He basically laid out a prosecutorial case against Michael in the book.
How was Fuhrman's book received? He was a controversial figure himself.
He was, absolutely. But the book was another huge bestseller. And the combination of Dunn's popular fictional take and Fuhrman's direct accusation, it created this undeniable pressure. The public was hooked, the media was buzzing, authorities really couldn't ignore it anymore.
So the media pressure forces law enforcement to take another serious look.
Yes. But ironically, perhaps the single most important development that gave prosecutors actual leverage came from the Skakel family itself.
Oh.
Well, back in the early 90s, before Dunn's or Fuhrman's books, Rushton Skakel had actually hired his own private investigators, a firm called Sutton Associates.
Why? What was the goal?
The stated goal was to clear the family name, to finally put the suspicions to rest. They were tasked with interviewing family members, friends, potential witnesses, trying to figure out what really happened, and presumably point the finger away from the Skakels.
Okay, sounds reasonable from their perspective. Did it work?
It backfired royally. The internal report produced by Sutton Associates, often called the Sutton Report, somehow got leaked. And instead of clearing the family, it ended up focusing intense suspicion squarely back on Michael Skakel.
What was in the report that was so damaging to Michael?
It contained details of interviews with Michael, where his story about the night of the murder had, well, it had changed significantly from his original alibi.
The alibi again. What was his new version?
Remember, his first story was, Left at 9:30 p.m., went to cousins, watched TV, came home at 11:30 p.m., went straight to bed.
Right.
The Sutton report revealed a different account Michael gave years later. In this version, he did say he went to his cousin's house. But he admitted that when he got back home around 11:30 p.m., he didn't go straight to bed.
What did he say he did instead?
He admitted that he went back out of the house, went over towards the Moxley property, climbed a large tree outside Martha's bedroom window, and masturbated while looking into her window, or trying to. He said he stayed there, doing that, until maybe 12:30 a.m. or even 1:30 a.m.
Whoa, okay, that is drastically different and incredibly damaging.
Absolutely devastating for him, for two huge reasons. First, it completely demolishes his original alibi of being safely asleep after 11:30 p.m.
And second,
It places him right outside the victim's house, in the dark, in a state of, well, sexual arousal and potentially frustration during the later part of the time frame when investigators believe Martha could have been killed. The estimated window of death was generally between 9:30 p.m. and maybe 12:30 a.m. or slightly later.
so his new story puts him right there, at the scene, acting strangely during the possible time of the murder.
Precisely. It provided prosecutors with a potential narrative. Maybe he was trying to get Martha's attention earlier. Maybe she rebuffed him, especially given her diary entry. Maybe he saw her with Tommy. And later, in this state of frustration or rage, he encountered her again or attacked her near her home.
Did he admit anything else in those Sutton interviews?
There was also an alleged statement he made to one of the investigators, something like, and the exact wording is disputed, "I remember running through the woods with a golf club in my hand that night," possibly adding he didn't know if it was the golf club. The defense argued this was taken out of context, maybe hypothetical.
But taken together, the radically changed alibi placing him at the scene, the window-peeping admission, this mention of running with a golf club.
It was dynamite. Even if the golf club comment was ambiguous, the changed alibi alone was a massive blow to his credibility. It gave prosecutors the ammunition they'd lacked for 25 years. Tag too big. The conviction and the reliability crisis.
Okay, so now you've got the media pressure cranked up, and you've got Michael Skakel's own words via the leaked Sutton report, completely changing his story and putting him at the scene. What happens next legally?
Things started moving pretty quickly then. In 1998, the state's attorney Jonathan Benedict took a significant step. He convened a one-person grand jury.
Is that common, a one-person grand jury?
No, it's quite rare. It's usually used for sensitive or complex cases where secrecy is paramount, or maybe to compel reluctant witnesses. A judge acts as the grand jury, hears evidence in secret, and decides if there's enough probable cause to issue an indictment.
And did this one-person grand jury find enough cause?
It did. After about 18 months of investigation, hearing testimony, reviewing the old files and the new information like the Sutton report, the judge indicted Michael Skakel for Martha Moxley's murder in January 2000.
And he was charged as?
Initially, he was charged as a juvenile because he was only 15 back in 1975 when the crime occurred.
But he wasn't tried as a juvenile, right? He was much older by then.
Exactly. He was 39 when he was indicted. There were legal arguments, but ultimately the prosecution successfully moved to have the case transferred to adult court. So he was tried as an adult, facing adult penalties, in 2002. He was 41 at the time of the trial.
And that trial, it didn't have much new physical evidence, did it? It still relied heavily on circumstantial stuff.
Almost entirely circumstantial. The prosecution built its case on a few key pillars. The Skakel family golf club being the weapon, Michael's drastically changed alibi placing him at the scene.
The diary entry suggesting tension.
Right. And then crucially, testimony about alleged confessions Michael supposedly made years after the murder while he was a student at a place called the Elan School.
Okay, the Elan School. This sounds important. What was it?
Elan was a private, very controversial residential school, kind of a reform school, in Maine. Michael attended it from 1978 to 1980. So this was a few years after the murder.
Why was he sent there?
He developed a pretty serious drinking problem after his mother's death, and the family sent him there hoping it would help him. But Elan was known for its extremely aggressive, some would say abusive, behavior modification methods.
What did that involve? What kind of methods?
It involved intense confrontational group therapy sessions. Tactics included humiliation, sleep deprivation, sometimes even physical restraint or abuse, often carried out by other students under staff direction. And a huge part of the program was forcing students to confess to past wrongdoings, real or imagined.
Forced confessions. That sounds problematic for using anything said there as evidence in a murder trial.
Hugely problematic. The defense argued exactly that. They said Elan created this incredibly coercive environment where students were under immense psychological pressure, sometimes even physical duress. They argued that students would often just make things up, confess to things they didn't do, simply to get the counselors and other students off their backs to stop the abuse.
So any confession from Elan needed to be viewed with extreme skepticism because of that context.
That was the defense's core argument regarding the Elan testimony. But the prosecution presented witnesses from Elan anyway, and their testimony was incredibly powerful for the jury.
Who are the key Elan witnesses for the prosecution?
There were several, but two stood out and were absolutely central to the conviction. The first was Gregory Coleman.
What did Coleman claim?
Coleman testified. His grand jury testimony was read into the record because he actually died of a heroin overdose before the trial started.
Okay, red flag right there, maybe.
Definitely a credibility issue, which the defense hammered on. Coleman had a history of drug addiction, a criminal record, but his testimony was explosive. He claimed that Michael Skakel, while at Elan, had bragged to him, quote, "I'm going to get away with murder. I'm a Kennedy."
Wow. That line connects everything the prosecution wanted to imply, the murder, the privilege, the arrogance.
Exactly. It was the soundbite that encapsulated the entire narrative against Michael. Even with Coleman's credibility issues, that alleged quote was devastating.
And who was the other key Elan witness?
John Higgins, another former Elan student. Higgins testified that Michael had confessed directly to him about killing Martha Moxley.
Did he provide details?
A motive. Higgins claimed Michael told him he'd killed Martha with a golf club after she had rejected or humiliated him somehow. This played right into the prosecution's theory about sexual frustration or jealousy, possibly related to Martha showing interest in Tommy instead of Micah.
So you have these two former students, years later, claiming Michael confessed at this controversial school. How did the defense fight back against that, besides pointing out the coercive nature of Elan?
They brought in other Elan alumni who testified that, yes, fake confessions were rampant. They testified that people would say anything to survive the program. They attacked the credibility of Coleman and Higgins, pointing to inconsistencies and potential motives for them to lie, like seeking attention or book deals.
But the jury believed Coleman and Higgins, or at least believed them enough.
Apparently so. The prosecution managed to weave it all together: the golf club from the house, Michael's lies about his alibi, the window peeping, the diary, and culminating in these Elan confessions. It created a compelling, if circumstantial, narrative.
And they used some pretty dramatic tactics in closing arguments too, didn't they, with audio tapes?
Yes, that was highly controversial. The prosecution obtained audio recordings of Michael Skakel talking, apparently for a book proposal he was involved with years later. In these tapes, he spoke about the night of the murder, specifically about the shame and panic he felt regarding the window peeping incident.
Okay, so taps of him admitting to the window peeping part of his story.
Right. But the prosecution, during their closing arguments, played excerpts of Michael's voice from these tapes talking about his actions that night, his panic, while simultaneously showing the jury graphic autopsy photos of Martha Moxley's body on a large screen.
Oh, wow. So they're overlaying his voice talking about peeping onto images of the murder victim.
Exactly. The implication was clear and deeply prejudicial. They were visually and orally linking his admission of a lesser, albeit disturbing, act directly to the murder itself, trying to make the jury feel that his panic wasn't about peeping, but about killing.
That sounds incredibly manipulative. Was it allowed?
The defense objected vehemently, but the judge allowed it. The prosecution argued it was just effective advocacy, using the defendant's own words and the evidence. But critics saw it as a deliberate attempt to inflame the jury's emotions and bridge the gap left by the lack of direct forensic evidence.
And ultimately, it worked. The jury convicted him.
Yes, in June 2002, the jury found Michael Skakel guilty of murder. He was sentenced to 20 years to life in prison.
But that wasn't the end of the story, not even close. The focus then shifted to the appeal process, right? And specifically to the lawyer who defended him at that trial. #TabV, the legal backlash and vacated conviction, 2013-2020.
That's exactly right. The conviction immediately triggered a long and complex appeals process. And the central argument wasn't really about challenging the evidence itself, the golf club, the alibi, the Elan testimony, although those were questioned. The main thrust of the appeals became what's called a habeas corpus claim.
Habeas corpus. That's basically arguing the imprisonment itself is unlawful.
Precisely. Skakel's lawyers argued his conviction was illegal because his constitutional rights had been violated during the trial. Specifically, they focused on the Sixth Amendment right to effective assistance of counsel. They claimed his trial lawyer didn't do a good enough job.
And who was his trial lawyer? He was pretty high profile, wasn't he?
Yes, Michael Sherman, a well-known Connecticut defense attorney. He took the case on, and it certainly raised his profile even further. But Skakel's appellate team argued that Sherman's performance was not just ineffective, but fundamentally flawed.
What were the specific complaints against Sherman? Was it just about strategy or more than that?
It was multifaceted. Skakel himself testified later during the habeas hearings that Sherman seemed almost starstruck by the case, more interested in the media attention and his own celebrity than in the nuts and bolts of the defense.
Any examples of that alleged behavior?
Skakel claimed Sherman would sometimes seem distracted. Even allegedly took inappropriate photos during the trial, like using a pen camera to photograph the judge or jury. He even claimed Sherman asked him, Skakel, for an autograph at one point.
If true, that's certainly unprofessional.
Highly. It painted a picture of a lawyer who perhaps wasn't fully focused on the immense task of defending a client in a high-stakes murder trial.
But courts usually need more than just claims of distraction to overturn a conviction based on ineffective counsel, right? There has to be a specific prejudicial error.
Absolutely. You have to show not only that the lawyer's performance was deficient, falling below professional standards, but also that this deficiency actually prejudiced the outcome of the trial, that it made a real difference.
And did Skakel's team find such an error in Sherman's work?
They argued several points, but the one that ultimately proved decisive, the one that led to the conviction being vacated years later, concerned Sherman's failure regarding a potential alibi witness.
An alibi witness Sherman didn't use or didn't find.
Didn't properly investigate or present. His name was Dennis Osorio.
Dennis Osorio. Why was he so important?
Because Osorio allegedly could have provided testimony supporting Michael Skakel's presence away from the crime scene during a absolutely critical time window on the night of the murder.
Which time window?
Remember, Michael's initial alibi involved going to his cousin Jimmy Terrian's house. Osorio was supposedly with Michael and Jimmy Terrian and others at the Terrian house that night. And crucially, Osorio apparently could have testified that Michael was definitely still at the Terrian house until at least 10:00 p.m., possibly later.
Okay, how does that time frame, being at the cousin's house until 10:00 p.m., significantly change things?
It's potentially huge, because many investigators, including some involved early on, believed the actual time of death was likely earlier in the evening, probably between 9:40 p.m. and 10:00 p.m., shortly after Tommy Skakel said Martha left him.
So if Osorio could place Michael definitively away from the Skakel and Moxley properties during that specific 9:30 to 10:00 p.m. window.
It directly contradicts the prosecution's narrative that Michael might have attacked Martha in a jealous rage shortly after she was with Tommy. It provides a concrete alibi for what some considered the most probable time of the murder.
And Sherman didn't call Osorio, didn't even talk to him properly.
The argument was that Sherman's efforts to investigate and secure Osorio's testimony were woefully inadequate. He knew Osorio existed, knew he was potentially important, but failed to follow through effectively, failed to ensure he would be a viable witness at trial.
Why would he fail to pursue such a crucial witness?
That's debated. Maybe he didn't think Osorio was credible, maybe he got sidetracked, maybe it was simple negligence, but the habeas court leader found this failure to be critical.
So this failure regarding Osorio became the key legal issue.
It became the linchpin. In 2013, after extensive habeas corpus hearings, a Connecticut judge, Thomas Bishop, agreed with Skakel's new lawyers. He issued a ruling vacating Michael Skakel's murder conviction.
Based primarily on the Osorio issue.
Yes. Judge Bishop's decision was scathing about Sherman's performance,
So,
particularly regarding the alibi witness.
yeah.
He wrote that Sherman's failure to pursue Osorio was significant and ultimately fatal to a constitutionally adequate defense. He ruled Skakel had been denied a fair trial.
So conviction overturned. Was Skakel released then?
Yes. After that ruling in late 2013, Michael Skakel was released from prison on $1.2 million bail. He had served more than 11 years.
But the state appealed that decision, right? This wasn't over yet.
Not by a long shot. This kicked off an absolutely dizzying legal roller coaster within the Connecticut judicial system. The state appealed Judge Bishop's habeas ruling to the Connecticut Supreme Court.
And what did the state's highest court say initially?
In December 2016, the Connecticut Supreme Court, in a very close 4-3 decision, actually reversed Judge Bishop's ruling. They reinstated Michael Skakel's murder conviction.
Wait, they put the conviction back. Why? What was their reasoning?
The majority in that 2016 decision essentially argued that, Even if Sherman made some errors, including possibly regarding Osorio, the overall evidence presented at the original trial was so strong they used the word overwhelming that Skakel couldn't prove the lawyer's mistakes actually changed the outcome. They felt the weight of the circumstantial evidence. The club, the alibi change, Elan, still pointed overwhelmingly to guilt, regardless of Sherman's performance.
So, back to square one for Skakel, facing prison again.
It seemed that way, but it was a deeply divided court, 4-3. The dissenting justices strongly disagreed, arguing that the right to effective counsel is fundamental and shouldn't be brushed aside just because the evidence seems strong. This division set the stage for yet another reversal.
The court changed its mind again.
Astonishingly, yes. Skakel's lawyers asked the court to reconsider, a relatively rare move. And in May 2018, the Connecticut Supreme Court, again in a 4-3 vote, reversed itself. They vacated the murder conviction once more, effectively upholding Judge Bishop's original habeas decision from 2013.
What caused the flip-flop within the court just 2 years later? Did the judges change?
One justice, who had been in the original 2016 majority, retired, and her replacement sided with the previous dissenters. But the legal reasoning also shifted subtly back towards the importance of the process itself. The new 2018 majority opinion focused squarely back on the ineffective assistance of counsel, specifically Sherman's failure regarding the alibi witness Osorio. They concluded that this failure was serious enough to undermine confidence in the verdict, regardless of how strong the other evidence might seem. Skakel's constitutional right to a fair trial, they ruled, had been violated.
So the 2018 decision essentially said the defense lawyer's mistake regarding Osorio was too significant to ignore, and Skakel deserved a new trial.
Exactly. The conviction was vacated again, this time seemingly for good at the state level. The state then tried to appeal this decision to the U.S. Supreme Court.
Did the U.S. Supreme Court take the case?
No. In 2019, they declined to hear it, which meant the Connecticut Supreme Court's 2018 decision stood. The conviction was officially off the books.
So the only option left for the state was to either retry Michael Skakel or drop the charges altogether.
That was the situation, and the decision fell to the chief state's attorney's office. What would they do, now facing the prospect of trying a 45-year-old murder case with evidence that old witnesses whose memories had faded or whose credibility was questionable, and knowing the original conviction had been thrown out due to constitutional errors?
What did they decide?
On October 30th, 2020, poignant timing, as it was the 45th anniversary of Martha Moxley's murder, the chief state's attorney, Richard Colangelo, announced the decision. The state of Connecticut would not seek to retry Michael Skakel.
Why not? What was the official reason?
Colangelo stated clearly that after reviewing the entire case, considering the passage of time, the unavailability of some witnesses, the fading memories, the credibility issues surrounding key testimonies like the Elan accounts, and the overall state of the aging evidence, the prosecution believed they could no longer meet the extraordinarily high burden of proving the case beyond a reasonable doubt to a new jury.
So it wasn't a declaration of innocence. It was a legal judgment that the case was now essentially unprovable in court.
Precisely. It was an acknowledgement of the legal and practical realities after 45 years and multiple overturned verdicts. The constitutional failures of the first trial, combined with the simple erosion of evidence over time, made a second prosecution untenable. Michael Skakel walked away legally cleared, though the shadow of suspicion for many remained. #tag60. Legacy and provocative thought.
It's such a complex and frankly unsatisfying end to such a long ordeal, especially when you think about Martha Moxley's family. Her mother, Dorothy.
Dorothy Moxley's perseverance throughout this entire saga is just incredible. She became this tireless advocate for her daughter, a real crusader, as some called her. She sat through every trial, every hearing, every appeal for decades.
Stoically enduring all those legal twists and turns you just described.
Absolutely. And even after that final decision in 2020 not to retry Skakel, her position remained unchanged. She stated very clearly, "I am sure that Michael is the young man who swung the golf club." Her certainty never wavered.
But did the family accept the legal outcome?
It seems they did, with resignation perhaps. Martha's brother, John Moxley, spoke for the family. He acknowledged their continued belief in Skakel's guilt, but said they understood the immense challenges prosecutors would face trying the case again after so long. He said they were at peace with the decision, recognizing the legal reality.
That's a remarkable amount of grace after fighting for so long.
It really is. It speaks volumes about their endurance and their eventual need for some kind of closure, even if it wasn't the closure they had sought for decades.
And beyond the family, this case just had such a huge cultural footprint, didn't it?
Oh, massive. We talked about Dunn's A Season in Purgatory and Furman's Murder in Greenwich. Those books, the TV movies they inspired, they kept the case alive in the public consciousness.
And it even generated books from within the extended family defending Skakel.
Right. Robert F. Kennedy Jr., Michael's cousin, wrote a book in 2016 called Framed: Why Michael Skakel Spent Over a Decade in Prison for a Murder He Didn't Commit. He argued passionately for Michael's innocence and even pointed fingers at other potential suspects.
So the case became this cultural battleground, too, reflecting these deep divisions about guilt, innocence, and privilege.
Absolutely.
Yeah.
It tapped into all these powerful narratives about the Kennedys, about wealth insulating people from justice, about the reliability of memory and testimony over time.
So when you boil it all down, this whole 45-year journey,
Yeah.
what's the core takeaway for someone trying to understand it all? What does it really mean?
I think it's a really stark illustration of where circumstantial evidence meets constitutional law, especially over a long period. You have these core facts that never really changed.
Mm-hmm.
The murder weapon came from the Skakel house.
Right.
The main suspect, Michael, gave demonstrably false alibis and changed his story significantly over time.
Mm-hmm.
And you had these alleged confessions, however problematic their context was. That combination was enough to convince a jury in 2002.
But it wasn't enough to survive the long legal battle afterward.
Exactly. Because the legal system, particularly through the habeas corpus process, eventually focused intensely on the process itself specifically, the documented failure of Skakel's defense lawyer to provide constitutionally adequate counsel. And that failure was ultimately deemed so significant that it invalidated the jury's verdict.
It's interesting. The same wealth and influence that people suspected shielded the family in 1975 might have also been what allowed Skakel to fund the incredibly expensive, decades-long legal fight needed to expose that flaw in his original defense.
That's a really sharp irony, isn't it? The resources that perhaps complicated the initial pursuit of truth also enabled the meticulous legal challenge that ultimately undid the conviction. It raises difficult questions about equity. Could someone without those resources have sustained such a fight?
Probably not.
It forces you to confront the limits of circumstantial justice. When a case rests so heavily on shifting stories, decades-old memories from potentially unreliable witnesses, and behavior interpretation, rather than on clear-cut forensic proof, it becomes incredibly vulnerable over time, especially when subjected to intense, well-funded legal scrutiny.
So maybe the most shocking thing isn't just the crime itself, but that after everything, a conviction, 11 years in prison, widespread public belief in his guilt, the legal system's final word is that the case against Michael Skakel, the only person ever charged, is unprovable.
That's the bottom line. Legally, Martha Moxley's murder remains unsolved. The system, prioritizing constitutional rights and the burden of proof, ultimately couldn't sustain the conviction. It's a powerful and for many deeply frustrating statement about the limitations of justice when time, influence, and legal procedure collide.
A truly sobering conclusion to a case that haunted so many for so long. Thank you for walking us through all those complex twists and turns today. This has been a fascinating deep dive.